Last month, a mining company watched a foreign government walk in and take a billion-dollar copper operation. The contract they signed was Airtight. The arbitration clause was textbook. None of it mattered. There's a reason your international contracts are currently worthless in 2026, and it has nothing to do with how they were drafted. It has to do with something I call the sovereignty squeeze. Now, by the end of this video, you'll know the one provision that separates the companies who recover their assets from the ones who lose everything. All right, let's dive into this one. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. And I've spent the last 3 decades representing clients in cross-border disputes across Latin America, Eastern Europe, and Africa. And right now, my desk looks different than it did even 6 months ago. Every other call is about a sanction trigger, a frozen account, or a regulator suddenly invoking national security. Now here's where it gets interesting. Investor-state arbitration filings hit a record high this year. The reason why is global fragmentation. Conflict zone disputes are no longer rare events. They're the new normal. Governments are weaponizing the phrase national security to do something that used to be unthinkable. They're seizing private foreign-owned assets in mining, semiconductors, rare earths, and AI infrastructure. And they're doing it under the cover of legitimate regulatory authority. This is what I call the sovereignty squeeze. A host country signs a bilateral investment treaty. You invest hundreds of millions based on those protections. Then the government passes a critical minerals law or a strategic technology decree. Now suddenly your operation is reclassified, your license is revoked, and your assets are nationalized in everything but name. Now you probably think, but I have an arbitration clause. ICSID protects me. The New York Convention forces enforcement. That's exactly what the mining company thought. And here's the truth that nobody's telling you. Your arbitration clause is only as strong as the forum where you can actually enforce it. That's why most international contracts are currently worthless. Not because the language is wrong, because the world that they were drafted for no longer exists. A 2018 contract pointing to an arbitral seat in a country now under sanctions is what I call a paper shield. It looks like protection, but it collapses on first contact. So stop drafting contracts the way you drafted them even 3 years ago. Stop assuming the seat you picked in 2019 is still neutral. Stop relying on a single forum. The companies winning investor-state dispute settlement claims right now are using what I call layered forum architecture. Now, they name a primary seat, they name a backup seat in a different legal tradition, and they name a fallback seat outside any sanctioned region. That's the playbook right now. Now, quick note before I get into the sovereignty squeeze playbook. If this is the kind of analysis you want more of, hit subscribe and hit that like button. It tells YouTube to push this content to other attorneys and business owners who actually need to hear it. Now, here's where it gets dangerous. The 2026 trend is governments invoking national security to do 3 specific things. First, force divestment of foreign ownership in critical mineral projects. Second, mandate data localization that effectively expropriates tech infrastructure. And third, impose export controls that make your operation commercially worthless without technically taking it. This is regulatory expropriation. And under most bilateral investment treaties, it absolutely qualifies as a compensable taking. But here's the catch. You only get compensated if you preserved your rights correctly in the first 90 days after the trigger event. I call this the notice window. Miss it and you've waived claims worth 9 figures. Now, most companies miss it because their general counsel is busy fighting fires at the operational level instead of building the arbitration record. That's how the sovereignty squeeze actually works. It's not one seizure, it's a sequence. Regulatory pressure first, then license revocation, then forced divestment, then the public reframing as a national security action. Each stage closes a legal door behind you. The notice window is the one door you have to walk through before it shuts. Now here's what most attorneys won't tell you. Sovereign immunity defenses are getting more aggressive. Countries that lose ICSID awards are simply refusing to pay. Russia, Venezuela, and several others are openly defying enforcement. So the recovery game has shifted. It's no longer about winning the award. It's about identifying attachable sovereign assets in third-party jurisdictions before you ever file a claim. Now you're sitting there thinking, this sounds expensive and complicated. And the reason why it feels that way is because it is. But the alternative is worse. The alternative is a final award you can frame on the wall with nothing in the bank. The one move that separates winners from losers is something I call the pre-dispute asset map. Before any conflict surfaces, you identify where the sovereign holds commercial assets in enforcement-friendly jurisdictions. New York, London, Singapore, the Netherlands. Then you draft your arbitration clause to channel any future award towards those exact venues. This is what the bigger players are doing right now in 2026. It's the reason why some companies are recovering and others are watching their counterparties laugh at the award. So when someone tells you your international contracts are currently worthless, they're half right. The old contracts are. The new ones, drafted with layered form architecture, a notice window protocol, and a pre-dispute asset map, are stronger than they've ever been. The sovereignty squeeze is real, but it's also survivable for the companies who prepare before the squeeze begins. If this video gave you something to think about, hit like and subscribe and share it with your in-house team. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.